for your viewers and listeners to know what has happened. Paragraph 2. Sometime in January 2018.
Paragraph 1 is very short, so
okay. So let me do 1.
Yeah,
it's because I don't want us to go the route of
that's okay.
Thank you. So 1, the first accused person, A1, and A1 here is Chairman Wontumi, a 50-year-old entrepreneur, is a native of Kuntunase in the Ashanti region. He's the sole shareholder. Kuntanase.
Kuntase, yes.
Thank you. In the Ashanti region, he is the sole shareholder and one of the 2 directors of the third accused person. That's A3, that's the company.
Wontumi Limited.
Yes. The second accused person, A2, we are told A2 is at large. I don't know whether he's in now. He's run away, he's gone. The second accused person, A2, is the other director of A3, which is the company, whose object is general farming, agriculture, business, and processing. Was incorporated and authorized to commence business on December 14, 2017, and this date is very important. 2, sometime in January 2018, A1 approached Ghana Export-Import Bank, the bank, for a grant of 19 million Ghana cedi. Now, Dr. Bonfe, please note it. A1 approach. A1 is Chairman Wontumi.
Yes.
He approached the Exim Bank for a grant of 19 million Ghana cedi.
For his personal.
Hold on, company. I'm reading.
Yes, go ahead.
Relax.
I'm interested.
Cedi facility to embark on a farming venture. In the application letter, A1 ostensibly as A3's managing director declared that a parcel of land, 100,000 acres in size, has been secured for the project. Accompanying the grant application letter are 2 documents. The first is a letter titled Board Resolution Letter and dated January 23, 2018. The letter was signed by A2, who described himself as the board chairman of A3. The letter stated that the grant application was authorized by A3's board of directors through a resolution passed on December 9th, 2017. Please take note of this date. According to the letter, the resolution happened on December 9th, 2017. We are told by the fact that the company was incorporated on December 14th, 2017. So if you submitted a letter to the bank with...
Check the date of incorporation again.
The date of incorporation is December 14th, 2017.
Look at it properly. Is that it? December 2017. 2017. Okay, earlier you had read 2019.
I'm
right, okay, thank you.
Okay, so it is December 14th, 2017, the date of incorporation. And he submitted a letter, a purported resolution of the board dated December 9, 2017.
Before the company was born.
Before the company was born. What could be more fraudulent than this? If it's true that these...
Exactly.
No, hold on. These are the facts. As
if it is true. You see, continue. Just
allow me. So the documents, as the state is alleging to have perused, indicates that the company was formed on December 14, 2017, whilst a document purported to be in the name of a non-existent company was on December 9, 2017.
And the prosecutors will be so incompetent to give us wrong dates on all of these things. So let's presume that the documents are what they are.
Yes. So to even proceed, you see, so I agree partially with Dr. Bonfe when he says that other persons must answer some questions. Because these were submitted to the bank, who are supposed to have people who at least should do some due diligence. But let's fast forward. I am saying that, you see, if these are the facts, as has been presented by the state, then I would respectfully submit that yes, a plea bargain is part of our laws. But in the agreement, I would respectfully, very respectfully submit that he should be made to either admit to some of these things, so that this issue of a plea bargain doesn't necessarily mean the person is guilty will not be there. If he refuses to do that, then I'll read some sections of the law. If he refuses to do that, let's go through the trial. Let's go through the trial. So that it's not made to appear as though, because this is, as Doc said, this is not a matter of demanding what has been taken from the bank.
Right.
It would have been a civil matter. But we are saying that you use fraud to secure the loan. That is what is before the court. It's not about how much has been taken and the fact that you have refused to pay. The reason we are in court, no, but you use fraud in securing the loan, which the state is so much determined to prove in court. But if you say that the state should not have that opportunity to prove in court, and you want to curtail the process and perhaps go by the agreement you have with the state, and let's also put it this way, it is not necessarily the case that every plea bargain would result in payment of money. Some, you know this.
Sometimes, so, maybe.
Sometimes. It's not always. Maybe we've even read here that it may even lead to maybe the reduction or the proffering a lesser, what do you call it? Punishment and even lesser charge and all that.
Sometimes the person is actually offering to become a witness or is offering to show you the other criminals, so to speak. That you may not get, but for that person.
Absolutely. So a lot happens. So we are saying that every Ghanaian would want to, honestly, unless he admits to this, that yes, and I'm sure in the agreement or in negotiating, a lot of these things will play out. If he refuses to admit that, yes, I did these things, I would respectfully submit that the AG should not go for it. Let us have this proof in court so that some of these comments will not come up. That, oh, he paid the money not because he's guilty. Because it is a matter of crime. We are not talking about the money he took and may not have paid back. We are saying that he used fraud, and that is what is before the court. So it is for the state to prove that indeed he used fraud. And that is, if you read the count one, it's the count one of...
You made that point, yes.
But you see, Bernard, you should also pay attention. Count 3.
Yes.
Go to count 3.
Money laundering.
Yes. So that is after you have taken the loan.
Yeah.
What you did with the money.
Because I don't have time, but the brief facts also tell us what he did with the money. Withdrawing from the third accused, the company, and using it for himself, putting some money elsewhere. It's all here, but because of time. You see, Sam, this is how far we have come as a people. Now, if you look at even the plea bargain, and we've said this, in fact, it is not automatic that even the AG agrees with whatever you are coming with. And the final decision rests even with the court. And if you read 162H, the court can even, if 168 of Act 1079, that is the Plea Bargain Act, popularly called the Criminal and Other Offences Procedure Amendment Act 2022, 162H, and with your permission, if I may read one. The court shall not accept a plea agreement unless the court is satisfied that A, the accused is of sound mind, B, the accused person entered into and signed the plea agreement voluntarily, C, there is a factual basis for the plea agreement. If the court is of the opinion that there is no factual basis for the plea agreement, the court, regardless of the agreement, the court may shoot it down. So it is not a fait accompli. It's not as if once you come up, I'll pay the money, and then that ends it. A lot would have to go into it. There are procedures. And so I am of the view that...
If you read 162H2.
162H2. Where the court accepts the plea, the court shall call on the... Yes, that's even important. Shall call on the accused person to plead to a charge in the plea agreement. So even 3, where the accused person pleads guilty to the charge, the court shall record the plea and convict the person, the accused person. So there will be a conviction. But you see, even with 4, if you don't plead guilty, the court shall treat the plea as withdrawn from the plea agreement and make order for the trial to proceed. So it's a long haul. And I am saying that to begin with, the AG in negotiating with him, if there should be any negotiation, should first test the sentiments of the people of Ghana in respect of this case, at least to be sure.
What's the sentiments of
Of course, people, and you've said it. Look, he's not guilty, don't go into any plea negotiation with him. If he says he's not guilty, that's my humble opinion.
Okay.
If he's no, of course, because the law affords the citizen the opportunity to trigger this.
No,
see, that's what I said earlier, that you shouldn't go into the realm where we suddenly will make the Attorney General so powerful that he decides whether the law has to be. No, the law. Listen, it says you go.
The thing is that unless the Attorney General withdraws the charge,
yes,
you must plead guilty. Otherwise, there's no plea.
Exactly.
Yes. But that's the law.
Yes. But
and the law has and the law has made provision for you to appear before the court. Respectfully, the judge, like I said earlier, there's some judicial supervision in there as well. The judge will want to make sure that, generally speaking, the right things are being done. So that's why I'm saying that we shouldn't let it look as if the AG is so powerful that now, because of somebody, you don't have to give them
let me come here quickly.
But you know that in practice, you know,